Chapter 11, Real Estate Contracts. In this chapter, we're going to describe the essential elements of a valid contract that are good for any contract that require any kind of contract to be valid, whether it be for real estate, to buy something, anything, or for an employment agreement even. Um, we're going to go over the essential elements that make any contract valid. Um, we're going to learn about the statute of frauds. We're going to identify different types of contracts and issues that affect the validity of contracts. We're going to explain various contracts used in the real estate business as well. So let's dive in. What is a contract? Pretty good question. So what is a contract? It's a voluntary agreement between legally competent parties to perform or refrain from performing some legal acts that is supported by legal consideration. Consideration is the compensation that we are paid for the services that we perform. All right. So, everybody got that? Now,
Yes.
there are four essential elements to any contract that make it valid, and they are competent parties. You have to have competent parties, offer and acceptance, consideration, and legality or purpose of the contract itself cannot be against public policy or the law. So these are the four essential elements of any contract. So let's highlight them. The four essential elements of a valid contract: competent parties, which means you in New Jersey, that's 18 years of age or older, just like many states, but let's focus on New Jersey. So, to enter into a legally binding contract in New Jersey, a person must be of legal age, which is 18 years of age and sound mind in order to be considered an adult. Now, New Jersey does permit, well, they don't anymore, but it says New Jersey permits a married minor who's at least 17 years of age to contract for the purpose of real estate. Persons under 18 may enter into valid contracts, but the contract is voidable by the minor until a reasonable time after they reach the age of 18. So it's not wise for an adult to enter into a contract with a minor because it's not legally enforceable, right? You can't enter contracts with minors because it's not legally enforceable to do so. If the minor doesn't hold up to their end of the deal, you can't force them to in a court of law. They're not considered a competent party. Now, there's business about married minors. Well, that doesn't play a role in New Jersey. Several years back, during the Trump administration, some he was big on human going after human traffickers, especially those that abuse children. He passed a lot of rules um, that went after people and held people responsible if they were even just passively allowing it to happen on their platforms online or what have you. Now, second Biden took office, he undid all that. Uh, so unfortunately, because he undid everything just with a sweep of his pen that Trump did. But those were a lot of protections in there. But either way, New Jersey advocates within the state of New Jersey for that advocated on the behalf of children actually passed law here in the state um, that you can't be married if you're under the age of 18, even with parental consent anymore. You know, because we got a lot of immigration that goes on, different customs in different countries. Hey, some countries it may be all right for a 60-year-old man to marry an 8-year-old. That's disgusting. That's child abuse. And it doesn't matter if your parents sold you to them and gave you consent, you know. So that was never allowed in New Jersey to begin with. However, New Jersey did allow parents, I think, as young as 16 with parental consent to get married. Well, that was done away with. No more. You can't be married in New Jersey unless you're 18 years of age. So there's actually a conflict. We noticed this because with a previous class that I looked up the laws on this during the class, and we found that this little clause here, 37 to 30, minor spouses have the authority to join adult spouse in the transfer of realty. Okay, well, you can't get married and be a minor in New Jersey. You can't be a spouse and a minor in New Jersey. So, how does that work? Does New Jersey honor other states' laws of marriage to minors? I'm not sure about that. That's a little bit different than New Jersey allowing other states. But so this is what you need to know for exams. When is a minor considered an adult and contracts legally binding with them if they're married minor? Okay. That's still on the exam like that. So just study it like that. But offer and acceptance. Okay, this is a requirement also known as mutual assent or the meeting of the minds. It's when the parties come together and they're in agreement and aware of all the terms of the contract, all the key terms of the contract. So that it's that's known as offer and acceptance or mutual assent. Consideration is the agreement. I'm sorry, it's the payment. It's what the parties agreed on as compensation to be shared between the parties. In order for any contract to be legally enforceable, something of value has to be exchanged between the parties, and that something is consideration. And there are three legal forms of consideration. They are legal tender, that's like money or a mortgage loan. An exchange of something of value. I'm going to give you this. In exchange, you're going to give me something else. Um, it's like bartering. Or love and affection. Yes, courts consider love and affection a legal form of consideration. No, they're not talking about prostitution. They're talking about like within a family, you know, a mother has love and affection for her child. So she only expects that to be the consideration that's given in return for maybe giving a house to your child or a car to your child or something in exchange. You know, you have love and affection for each other. But in that case, you have to also be accompany it with a letter stating that it is in fact a gift. So the price or amount must definitely be stated and payable in exchange for the deed or right received. In a sales contract, the consideration is the entire purchase price. And then we have legality of the object or purpose of the contract. To be valid and enforceable, a contract must not involve a purpose that's against public policy or the law. All right. And then we also highlight a valid contract may be oral or written. It could be verbal. You could have a verbal contract, and that contract could be enforceable, but it's difficult to enforce. You know, how do you prove you said something, right? If you didn't get it on paper. So the parole evidence rule states that the written contract would take precedence over oral agreements or promises. If somebody claims they had a verbal one and someone else has it in writing, the judge will kick out the verbal one in favor of the one in writing. It only makes sense because you have evidence. Thus, the name parole evidence rule has to deal with having it in writing. All right, so you guys have all these highlights and underlines and such? Hello.
I'm good.
All right. Okay, so once again, just to recap, competent parties, you got to be at least 18 years of age or older. A sound mind, sane, sober adults with no mental disease or defect. Legal age. If under 18, the contract's voidable by the minor. Can't hold a minor to a contract unless they're married for exam purposes. Um, and because look, under no circumstances can a minor be considered an adult in New Jersey any longer in real life. And I'll show that to you right now. I'll just click on that. We could go to the link on Find Law. And here's one, for example. This actually happened in September 14th. Okay, this was last reviewed or updated September 14th, 2020. Anyone who's of the age of majority, 18 in most states, okay, you can marry whoever you want. Okay, now here's what it is in New Jersey. Many states have marriage age limits. Used to be in New Jersey, you get married as young as 16 with parental consent, um, or a court could approve that. But June 2018, the New Jersey became one of the first states to ban child marriages. Ooh, sounds harsh when you word it like that, right? Marriage with parental consent. Oh, it sounds so soft, but let's word it like this. Let's call it what it is, child marriage. Okay. So child marriages, there's a clear minimum age of 18 in New Jersey, without exception. No exceptions to that. So why do they have that rule? We went and we looked at and we looked up some of the other legal requirements. Let me see, New Jersey annulment and prohibited marriage laws. Okay, we're not going to dive big into this because we're not attorneys, but we just need to know the basics of it. And I did point out to you that minor spouses with authority to join adult spouses in the transfer of realty. That's 37230. And this law also fell under that statute, 3716, actually. Okay. That banned child marriages. And the other law says, though, if you are a child and married, you can enter into a contract. I guess our politicians didn't fix things or think it out too clearly or clear up existing laws that they had on the books when they changed the laws. And that's not uncommon for our New Jersey politicians. They love to make new laws, but they rarely go and search and amend other ones that need be. So we probably got a lot of conflicts here in our books. All right, so offer and acceptance, mutual assent. When the parties are in agreement to all terms of the contract, they're in agreement and aware of all the terms of the contract. It's said that they've come to a meeting of the minds. We're here, we understand each other, right? That's what offer and acceptance or meeting of the minds is. Now, the parties are aware of and in agreement on all the terms, which must be clearly stated and understood by the parties. Now, for state exam, that's the definition. The meeting of the minds, the parties are in agreement and aware of all the terms of the contract. For school exam, they focus more on the money. You know, when the parties are in agreement on price, down payment, and how you coming up with the rest of the cash, the financing method. Okay, so that's the definition you need to know for the school exam. When the parties are in agreement on price, down payment, and financing method. For state, it's just when the parties are aware of and in agreement on all the terms. Okay. So once again, consideration, it's what the parties give or receive from each other. I will give you this in exchange for that, or I'm going to do this in exchange, you're going to give me that. So it could be for goods or services. It's the entire purchase price. And there's three legal forms of consideration. Legal tender, that's money or mortgage loan, an exchange of something of value, goods or services, and love and affection. However, that needs to be accompanied by a letter that says, in fact, that it is a gift. And then legality of the object or purpose of the contract. You cannot have a contract to kill somebody, for example, because murder is illegal, right? So whatever the purposes of the contract has to be cannot be against public policy, can't be against the law. Okay? Um, in short. So you need to know this for exams. What are the 4 essential elements to make any contract valid? You need to know that when can a minor enter into a legally binding contract with an adult if they're married? And what are the 3 essential elements to any valid contract? What are the 3 essential, the 3 forms of consideration, the 3 legal forms of consideration? Okay. So once again, competent parties, offer and acceptance, consideration, and legality of the object or purpose. What are the 3 forms of consideration? Legal tender, exchange of value, love and affection. When can a minor legally enter into a contract and it be enforceable with an adult? If they're married. Got that? Everybody good? You see all these questions? It just came from this little part right here.
Got it. Thank you.
You will get a lot of questions from this chapter, by the way, on exams too. Contracts are a big deal in real estate. So yeah, you're going to get a lot of questions from this section too. All right, so the parole evidence rule we also highlighted. That's when somebody has a verbal contract and someone else got it in writing, the court will favor the one who's got it in writing. That serves as their evidence, thus the parole evidence rule name there. Now, the terms amendments and addenda. We should familiarize ourselves with these. We often use them when dealing with contracts. So anytime a contract is modified, those changes must be agreed to in writing by both parties. Otherwise, you just voided the contract. And you know what a void contract is? It's not a valid one. What does that mean? It's not legally enforceable. So licensees must not make any changes or additions to a contract after both parties have signed one. This is practicing law without a license. So the difference between amendments and addenda. Amend, look, it has the word mend in it. What does mend mean? It means to fix something, right? And addenda has the word add in it. You're adding something to a contract. So amendment, you're changing or modifying something, you're mending it, you're fixing it. And addenda has the word add in it, so you're adding something to the contract. Everybody got that?
Yep.
Okay. Let's underline that there. You're either amending it or you're adding to it. All right. So amendments and addenda, we could highlight that stuff here. And I wrote some chicken scratch here in the side. This is what I wrote in the side. What you see in the box down here at the bottom. Licensees must not make any changes or additions to the contract after both parties signed it. This is practicing law without a license. And you're highlighting an amendment is a change used by the signing parties to correct or clarify something in the original contract. The changes must be dated and signed. So you should put maybe a little circle next to it, and in that circle, you'll put the initials of both parties and the initials by both parties and the dates. Otherwise, but next to every single change. And if both parties don't, or all the parties to the contract don't initial and change next to every modification, contract's void. It's not enforceable. Now, an addendum is a separate document, sometimes called a rider. It's something that alters the terms of the original contract because you're adding something to it. A separate document. You're adding an additional entire document. Now, either party can originate an addendum, but it must be signed by all parties to be legally binding. Disclosures, updates, terms, modifications, clarifications, etc. Let me know when you have this written here on the side and you got these highlights done.
Okay. Okay, got it.
Okay. Everybody good, or anybody still writing? All right.
I'm good.
So real estate licensees follow both contract law as well as licensing law. So the Real Estate Commission's rules state that to be entitled to a commission, a real estate broker cannot be paid unless they have some sort of authorization in writing by our client or customer to be entitled to earn a commission. So we need to have, we do that either in listing agreements, exclusive buyer agency agreements, designated agency agreements, transaction broker agreements, or referral agreements, or the commission's usually stated now in something what we call a BSA, the brokerage service agreements. So let me add that there. BSA, brokerage services agreement. And it needs to be signed by the consumer. And anytime we sign a contract with the consumer, we must give them a duplicate original immediately. You guys recall what a duplicate original is, right? Copies with original signatures. So it's basically many originals. And this applies only to the sale or lease contracts, no matter, or this applies to sale or lease contracts, no matter who the broker is working for, on behalf of the seller, buyer, landlord, or tenant. The statute of frauds. All right. This is just dealing with general contract law. But then pertaining to statute of frauds, we could apply it also to real estate. So sales contracts for real estate must always be in writing. Always. In New Jersey, in order to, you cannot have a verbal agreement to sell real estate. It has to be in writing. Leases, however, do not, unless they're 3 or more years in length. Now, real estate licensees, that's what contract law says. However, real estate licensees, we also follow the Real Estate Commission, the real estate laws and the rules of the Real Estate Commission. And they say if a licensee is involved, we must always get the contract in writing, no matter the length. It could be for a month, the lease. it needs to be in writing if a real estate agent's involved. Leases, however, can be recorded in the public record if they're 2 years or longer. So general contract law says that New Jersey can have verbal leases as long as they're under 3 years. 3 or more years, they need to be in writing. If a real estate agent's involved, doesn't matter the length, it needs to be in writing. Got it?
Got it.
Got it.
So let's highlight that here now, 196. The statute of frauds states that the contract for sale of real estate and any lease for more than 3 years must be in writing and signed in order to be enforceable. And then add there the words, leases longer than 2 years can be recorded. What does that mean to record a document? When you record something, what are you doing?
Contract?
Yeah, but when you record something, what are you doing with that contract?
You put it on record with
You're,
With the
where?
with the government.
Okay,
Or
so you're adding it to the public records.
Oh,
With the county, that's at the county level. You're recording it in the county courthouse, okay, where all the documents pertaining to ownership of the real estate are located. Just let me know when you guys have these highlights and that note. Have it, I guess, by now? Yeah?
I took a screenshot.
yes.
Okay. All right, just need to let you guys just gotta let me know when you got it so I can keep it rolling. Got a lot to get through. Okay, so contracts can be express or implied. They could be unilateral or bilateral, executory or executed, valid, unenforceable, voidable, or void. And we're going to learn what all these terms mean now in the coming pages. So an express and an implied. Let's hit that up first. Let's do these highlights, and then we'll go to the next slide for the definitions that I made. So we'll just highlight these definitions in the book, and then we'll go over the next slide, which goes over the definitions that I give. And let me know when you got all that.
Okay, got it.
All right, is everybody good? Everybody got?
I'm good too.
Okay. So an express contract is one that lays out all the terms, expressing them in words, leaving nothing to interpretation. So those words are usually in writing. An implied contract, however, is one that's expressed by one's actions rather than their words. Now, this is demonstrated by your acts and conduct. It's usually not in writing, and therefore, it may leave some things to interpretation and may cause some confusion. Some examples of an implied contract are a lease. That lease expired, and the tenant pays the landlord, and the landlord accepts the payment, but the tenant never signed a new lease. It's implied that they were going to continue renting there by the actions of the landlord accepting that payment from the tenant. It's implied that they're going to continue leasing there month to month now. Now, some things that could cause confusion and interpretation is, well, according to what terms? The terms that we previously had in a lease, or something different? How does that work? Well, because you didn't state it in words, in writing, it leaves something to interpretation, right? Now, if a bank accepts a payment, here's another example. If a bank accepts a payment from an owner after the foreclosure process begins, this could be interpreted by the courts that there's some sort of an agreement between the lender and the owner for an alternate form of repayment for that outstanding balance. So the payment would serve as the borrower's evidence if they were to make such a claim that, hey, I was under the impression, or the bank told me that I could pay it back little by little until I get caught up, and it wouldn't be an issue. So if they could show that they made a payment and the bank accepted it after someone was already in foreclosure, well, there's pretty good evidence there by the bank's actions to indicate that, yeah, that may be true. That's possible. So that's just another example, by their actions rather than their words. Now, unilateral contract, uni means one. It's a one-sided agreement. So a contract where one party is required to do something, but only if the other party acts. However, they're not required to. A contract where one party has an obligation to perform and the other has an option to is another way to word that. So option agreements must be prepared by attorneys, not by real estate licensees. Otherwise, you're practicing law without a license. Here's an example of a unilateral contract, one that gives someone an option. If it says something like this, I will do this, and you, if you will do that. If you can apply that statement to your situation, that one party's going to do something, but only if the other does something, that's a unilateral contract. Whereas a bilateral contract, the litmus test would be, I will do this and you will do that. Both parties have an obligation to do something. And contracts can be executed. When we talk about executed contracts, we're usually talking about whether they were signed or not. So an executed contract is one that's been signed. Fully executed contract is one that's been signed by everybody. But the fully executed could have two meanings to it. The alternate meaning could be, if a contract's been fully executed, it could mean that all the terms of that contract have been fully performed and carried out, and there's nothing left to be done. And then we have an executory contract, ending in tory, meaning it's still in progress. Therefore, all the terms of the contract have not yet been fulfilled. There's still things that need to be done. So, for example, if a contract has been signed by everybody, what do we say that it's been fully executed? But what status is the contract in at that point if it's just been signed by everybody? Well, you still need to do what the contract required of you, so it's an executory status at that point. Okay. So 197 is this, 198, it's continued here. And you got the highlights like that. Okay, so this is split between two pages, executed, executory, and then, well, let's just highlight this. An executed contract can be one that's a signed contract. A fully executed contract is one that's signed by all parties. That's probably the only thing that you really need to know there. Okay.
I'm good.
So contracts can be valid, void, voidable, or unenforceable. A valid contract is one that contains all the essential elements. So therefore, it's legally enforceable in the court of law. A void contract is one that's missing one of those essential elements, or the contract's been broken in some way, shape, or form that it's no longer enforceable. That would be a void contract. Now, a voidable contract is one that seems on the surface to be valid. However, one of the parties cannot enforce it, like a contract with a minor. The adult cannot enforce the contract against the minor. An unenforceable contract also seems on the surface to be valid. However, neither party can sue to force performance. An example of this would be you got two people, they get into a contract, one gets into a contract to buy the other's property. However, they were both drunk out of their minds when they signed the contract, or they were high or something. Neither party was competent at the time that they signed. So therefore, the contract is not enforceable by either party. Neither one of them was competent. However, if when they sober up, they both wish to remain in contract with each other, it said the contract is valid between the parties and they could perform. There's nothing to stop them from fully performing it. But one party can't sue the other to perform. You got it?
Got it.
Got it.
So that's valid, voidable, unenforceable, and void. I got those here. I kind of trimmed down those definitions all in one slide, so it makes it easier to study if you want to grab a screenshot there. Okay.
I'm good.
Now, so to be valid, a contract must be signed as a free and voluntary act of each party. Undue influence means that you are taken advantage of. You must use extreme caution when dealing with elderly people or those who may be under the influence of drugs or alcohol. You should also try to keep aware of to detect any possibility of a mental disease or defect that's going on in the person's head there. I mean, we're not psychologists. We can't see what's going on inside people's heads either. But you can kind of tell sometimes when people are a little screwy, right? You may get hints of that if you're intuitive and you pay attention. So be careful when taking a listing from someone who's older. Be respectful, though. Be respectful of older people. Don't assume that just because you're older, your cheese is sliding from your cracker, if you know what I'm saying. But it is possible sometimes people could have Alzheimer's or dementia. They seem perfectly lucid. They know exactly what's going on around them. They're not always just shaky and confused people. Sometimes they seem like they're sharp as a tack. Um, but you ask them what year it is, and they're like, yeah, it's 1938, and it's like, yeah, you're off a little bit there, Yeah, they think their child is their spouse, their cheese is sliding off their cracker, but it may not be so obvious at the beginning. So you got to be careful about that because if you do enter into a contract with somebody who's not of sound mind, um, you can't enforce a contract against somebody like that. They're insane. They have Alzheimer's, dementia, etc. I put bipolar or other diseases there. I mean, it really depends. Some of these can be really extreme, and you could take advantage of them. Now, duress, that's force, threats, or intimidation. Um, Listen, elderly people, those not of sound mind, those in hospital beds who think that they are dying, or just in a lot of pain. They may be under a lot of stress, and you could be taking advantage of them, unduly influencing their decision in selling a property. You should not be going to visit anybody in a hospital bed to sign a contract. That's a that's kind of a red flag indication that there may be something amiss there. You know. If you got to go to the hospital bed to get somebody to sign a contract, they should be appointing somebody to handle um, their legal affairs if they're not competent enough to do it on their own. All right, coming up, we're going to talk about performance of a contract, and we're going to learn that dates are merely guidelines to follow, and you're not in breach of contract if you miss a date to do something in a contract, normally. Now, we're going to learn about the term time is of the essence. We're going to learn about different ways contracts can be discharged. We're going to learn the term default or breach of contract and the statute of limitations for lawsuits. All right. So, statute of limitations is a time limit in which one has a right to assert their legal rights. There's a 6-year statute of limitations for contracts, foreclosures, mortgages, and cases of fraud. And there's a 10-year lawsuit for to recover real property in New Jersey. And remember, keep in mind the record keeping requirements for brokers. We're required to keep all records for 6 years. Statute of limitations for contract lawsuits, 6 years. I wonder if that has something to do with that. So we're required to keep all contracts for all records for 6 years, except for expired listings and unaccepted offers that we only keep for 6 months. Okay, so we got some time frames here, all to study on one slide. And let's do those highlights of those things right here on 198 and 199.
Got it.
Okay.
I'm good.
So breach of contract or default is when someone breaks the contractual agreement without having a good legal excuse to do so. In those cases, they can be held liable to the other party. And dates in contracts are merely guidelines. Nobody's considered in breach of contract if a date to perform some act that is stated in the contract is not performed by that date. It's not a deadline that makes you in breach of contract if you don't. However, sometimes we want to make sure that things get done by certain dates. It's very important they do. In that case, time is of the essence, so to speak. So, time is of the essence is a term that should be left for attorneys to use. We could ask attorneys to issue a time of the essence order, but we should leave that up to attorneys. This is a strict deadline that must be met. And if anybody does not meet that, whatever needs to be performed on time, when a time of the essence order has been issued, they're guilty of breach of contract. So use of that term should be strictly left to attorneys because it is a double-edged sword in meaning that it does cut both ways for both parties. You have a time, a deadline where both parties must perform some legal acts. Okay. So let's highlight that in 199.
Got it.
Okay. Now, assignment and novation. Assigning a contract or assuming a contract is when you're taking over someone's legal obligations, their contractual legal obligations. However, that original person is never relieved of their original contractual obligations. So when one party signs a contract, their contractual obligations over to another. When they do this, though, they're never relieved of their original obligations. So if that person who took over assumed those legal obligations does not perform like they're supposed to, the original person that signed the contract is still responsible. One example of this is a sublease. When you're leasing from a landlord and you want to get out of that lease, the landlord won't let you out of it if, and that's a big if, they were to allow you to sublease to someone else. You could sign a sublease with a new tenant who will take over your lease. However, if they violate the lease in some way, like not paying the rent, for an example, the original renter is still liable to the landlord for the payment of the rent. You got it?
Mm-hmm.
Okay, no rocket science here, right? We're humming along, but this is still stuff to know. Now, what if we want to assign our contractual duties to someone else and not be not have any further liability in the event that they don't hold up to their end of the bargain? Well, we could always novate the contract if the other party agrees to it. Once again, this is only if the other party agrees. You could novate the contract. Novation is substituting or replacing an existing contract with a new agreement, where the old agreement is no longer legal. It has no legal force. It's not legally enforceable. Or you could substitute a person named in the contract with another. It's the same kind of deal, except instead of replacing the whole contract, you're replacing the person named in the contract with someone else. So the original person in the contract no longer has any legal obligations. All right. So let's highlight for assignment and novation the book's definitions for that. Excuse me.
Got it. Got it.
Okay.
I'm good as well.
Goody, goody, good. So these are different ways a contract can be discharged. A contract could be completely performed with all of its terms being carried out, or it may be breached. That means broken without having a good legal excuse to do so. And if one of the parties does default, in addition, there's various other methods by which a contract may be discharged. And those include partial performance. The parties only partially did what the contract required of them. So they didn't do everything the contract required them to do. Then we have substantial performance, where they did everything what the contract required them to do. They just didn't do it exactly the way the contract required them to do it. Impossibility of performance is when the terms of the contract can't be legally accomplished. You can't get a permit, as an example, to use a property for its intended purpose any longer. You're unable to get the CO due to some reason, or some other legal condition cannot be met. It's therefore impossible to perform the contract. Or by mutual agreement, both parties can simply agree to back out. Or by operation of law, like voiding a contract as a result of fraud, or contract with a minor, expiration of a statute of limitations, or contracts being altered without all the parties agreeing to the terms. Remember, consent for any changes to a contract is required by all parties for it to be legally binding. Anytime you make changes to a contract, all parties need to agree to those changes, otherwise you just voided the contract. So default or breach, once again, is when somebody violates the terms of the contract without having a good legal excuse to do so. Back on page 73, we highlighted what an injunction is, and that's when a judge orders somebody to do something or to refrain from doing something. So we're going to go over now what happens if a seller defaults, what are the buyer's options, what can they do? And then we're going to go over the if the buyer defaults, what can the seller do? Before we do, though, it looks like we have something else we got to go through here. The term liquidated damages. Liquidated damages is just an agreement made in advance about how much money will serve as compensation in the event that one of the parties, usually the buyer, defaults on the contract. So let's highlight this on page 219. Is that on page 202 or is that just on page 219? Okay, on page 200, they just mentioned that word, but 219, we're going to go and highlight the definition that, as you see here in the screenshot. And then we're going to come right back to 200.
Got it.
I'm good too.
All right. So liquidated damages, once again, is just an amount of money that serves as compensation in the event one of the parties breaches the contract. It doesn't specify where the money's coming from, but if it does, then there can't be any additional money that can be claimed from other places. So if for an example in a contract you say in the event that the buyer breaches the contract, their security deposit's going to serve as liquidated damages. If you do say that, then that means that the seller can only claim the money as damages that was put up for the deposit. See, liquidated damage agreements could be well beyond that amount. And then you just have to make a claim that, hey, they contractually agreed to give money and be responsible for this amount of money. And then, but however, they did put the deposit down. We'd like to keep that deposit then. Okay, that's different than saying in a contract that the good faith deposit money that the buyer put down will serve as compensation, because then whatever that money is, that's all that you could collect. If you say in the contract that liquidated damages is a certain amount, you could say, okay, well, they have some in the some money that they put down as a deposit. We'd like to keep that to start with, and then we're going to go after them for the balance still. You guys have an understanding there what liquidated damages is? It's just an agreement on how much money is going to serve as the compensation. It does not specify where that money's coming from.
Okay.
Okay, it's important to understand that for exam. I want to get it right on exams. All right, so if a buyer defaults, what can the seller do? Well, if a liquidated damage agreement was added to the contract, it is not standard in all contracts, although the book makes it sound like it is. The seller can declare the contract forfeited if the seller stated they can, and if it was agreed to that they'd be awarded compensation from the buyer as liquidated damages. The seller can rescind the contract as if it were never made. However, that would require them to return all the deposit monies to that would-be buyer. The seller can sue the buyer for specific performance. However, this would require them to sign over the deed to the buyer and then chase after them for the money, saying, Ooh, look, I just gave you the property. Now you need to pay me for it. The seller can sue the buyer for specific performance. What is specific performance? It's a lawsuit where you now need to chase after them for the money because you signed over the property to them, and now you need to get them to pay you for it. So the seller can sue for compensatory damages too. They could force the buyer to pay them compensation. That's compensatory damages. So let's do these highlights about if the seller defaults, the buyer has three alternatives. If the buyer defaults, the seller can do this. Okay, you could just underline these. You don't got to put it in a box and highlight it. These are just the titles that weren't shaded. They could have been shaded by the book manufacturer. So you could just underline these or put a box around them or highlight it, whatever you choose to do.
Got it.
Everybody good?
Yes, I'm good as well.
All right. So contracts that we use in the real estate business, we don't create them from scratch. They've already been created and approved by the Real Estate Commission. We just fill in the blanks. We just fill in the blanks as to what we want to add to the contract. So New Jersey licensees, we can only prepare sales contracts for 1 to 4 families and single residential lots. Anything else is considered commercial property, and we prepare those contracts with a non-binding intent to purchase or lease, also referred to as a term sheet, which I got a link here to one of those term sheets in the shared Google Drive right here. Non-binding proposed term sheet for commercial or industrial property. You see that? It shows that this is not legally binding. This is just where you're going to lay out the terms that you want an attorney later to add into the contract. All the details. See, it's blank. All right. And contracts must indicate the business relationship the parties have with each other. We do that in the contract itself for leases and sales contracts. We also do that on the Opinion 26 notice, which states the different ways we could work with somebody. but the opinion 26 notice has that checkbox showing that. And then there's and then it tells people that they have a right to hire a lawyer. You see, remember the checkbox here in the opinion 26 notice? There's a checkbox showing how we could work with them, and then all the rest of the document just advises them that they have a right to hire a lawyer. Because we have to advise them of what their rights are. Can't deprive them of their rights. And then New Jersey contracts for sale or lease, they must be prepared by those contracts for residential property can be prepared by licensees. But they should have the terms they should have the words at the top of the page of the first page of the contract that says, this is a legally binding contract. Now, what the phrase fully says is this is a legally binding contract that will become final and binding within 3 business days. And during this period, you may choose to consult an attorney who can review and cancel the contract. And all contracts prepared by licensees must disclose the agency relationships, who they're working with and how on a contract. And here's some screenshots of it from an actual sales contract. It says, you see this at the top of the contract? It says, this is a legally binding contract. This is from a screenshot from page 202 in this book, the first page of the contract. Now, that's not all it says, this is a legally binding contract. You know, it has more to it than that. But I just want to give you an image where you could see what it, you know, how and where it says that.
Yeah.
Okay. So, attorney review, how does that work in the sales contract? Well, attorney review, the parties need to be given at least 3 days to start it. But some people think that attorney review is 3 days. It's not necessarily 3 days. I've had attorney review done in an hour. Attorney review, you got to get, each party has to give the other 3 days to respond to their last correspondence. And when we start a sales contract or a lease contract, we have to give people the right to hire a lawyer. And they have 3 days to start that attorney review. Otherwise, the contract becomes legally binding as it is. So how does this work? Well, this is what the attorney review looks like on words. It says, these are the stages of attorney review. Study by the attorneys. Both parties must receive the duplicate original of the sales contract. And then we start counting of time to start that attorney review. You don't count, you count 3 business days. We don't count weekends or legal holidays. The review period can be extended or temporarily halted if both sides agree to it. And to begin the attorney review, to make modifications or cancel the contract, or otherwise it becomes legally binding as it is. And nobody can make changes to the contract without the other side's approval, even if you hire a lawyer. So attorney review works like this. After both parties sign the contract, they get their duplicate original. Within 3 days, you have to get that 3 business days. You got to get that contract out to the attorneys, and one of the attorneys has to respond to it, starting the review process. And we call that the notice of disapproval, where one side's attorney starts the review process by acknowledging that they received the contract and then proposing any changes that they wish to have made to it. Otherwise, they'll accept the contract. And now we could call this that they've reached a meeting of the minds and they've accepted the contract as it is, and you're now in a legally binding contract with each other. That's basically how attorney review works. So basically, when the one side gets a contract, they say we disapprove of the contract in its current format. However, if pending these laundry list of proposed changes is here, if you agree to them, we will conclude attorney review and be in a legally binding contract. Otherwise, and then they'll say sign here. Otherwise, the other side will review that changes, the proposed changes, and then they'll send a letter back. We're in receipt of your review letter, and we disapprove of that contract, but we can approve it with the following changes. And you guys can just go back and forth like that over and over until the other party agrees to the last party's proposed changes, and then you're now in a legally binding contract. That's the way that it works. Okay. So, contracts for sale or lease, they also have to have disclosure in the contracts about the lead paint that we've given you, that separate lead paint disclosure statement, separate from the contract. Giving you a 10-day opportunity to conduct an inspection or waive that inspection right. And the lead pamphlet, the book about hazards, lead hazards in the home, has to be given to potential buyers and renters of that property. Okay.
Yeah.
So in our contracts, we use listing agreements. Each MLS has their own. Some include the BSA, the brokerage service agreement, that talks about commissions, and others don't. We have exclusive buyer's agency agreements. We have our designated agency agreements, transaction brokerage agreements. Although there's no universal one, those need to be custom written. We have dual agency, disclosed dual agency agreements. And we have the CIS form, which is the first document we give to anyone that tells you the different business relationships and different ways that an agency can work with somebody. Now, there's no official name for the sales contract. You could call it a sales contract. You could call it a purchase contract. It goes by many names. Offer to purchase, offer of purchase and sale, earnest money agreement, binder and deposit receipt. There's no official name is the point there. So call it whatever the hell you want. Just don't be all high and mighty thinking whatever you call it, that's what everybody else needs to call it as well. That's the point that they're getting at here. So I guess there is no real point. Okay, so that is the deal with the sales contract or purchase contract or whatever you want to call it, like I said. So offer and acceptance. One of the essential elements of a contract is when the parties come to a meeting of the minds. They agree on all the terms of the contract. A broker lists an owner's real estate for sale at the price and conditions that are set by the owner. Who sets the prices? The owner does.
The owner.
We help guide them through that process by doing a CMA, perhaps. However, who ultimately does set the asking price on that property? That would be the property owner. We just help try to guide them in that process. By doing that CMA. Help educate them a little bit. You guys get this? Bottom of page 216.
Yeah.
All right. Now this is page. So this is the bottom of page 216, at least the first two lines of this is, and then the rest of this is on page 217. So this is like the second paragraph on page 217 here. Let me make a little note to that in this slideshow. Offer and acceptance. Just let me know when you got it all.
Look at it.
Hey, everybody good?
I'm good.
So here's my breakdown of how the offer and acceptance process works instead of just reading it from the book. I like my breakdown a little bit better here. My explanation is a little bit better. So here's the deal. One of the essential elements of a valid contract is a meeting of the minds, where the parties to the contract are aware and in agreement of all the terms of the contract. And this is done through the process of offer and acceptance. So first, the seller lists their property for sale at a certain agreed upon price. Then a buyer makes an offer at the full listing price or perhaps another amount, which the broker then presents to the seller's agent, the seller and their agent, or just the seller's agent, within 24 hours. Then the seller either accepts the offer as it is, they could reject it, or they could make a counter offer, which basically essentially is a rejection of the offer, but the seller's countering it with another offer. So at this point, the buyer's free to walk away if that happens. Now, if the seller makes a counter offer, and the buyer can then either accept it, reject it, or they can make their own counter offer back again. And they could go back and forth like this until one of the parties finally agrees to the other's terms. And when they do, this is called a meeting of the minds. They've reached the meeting of the minds, and the offer is accepted pending attorney review. They're still not in a legally binding contract yet until that attorney review period is over or the 3 days has passed without starting an attorney review. And then they become an illegally binding contract as it is. So, in contract negotiations, when is an offer considered accepted? When the last person who made an offer was simply notified of the of their or their agent's been notified that their offer's been accepted. Now, why do I say or their agent's been notified? Because anything that is told to your agent in the eyes of the law, you've been informed about. And why is that? It's because they have a fiduciary duty to report back, to notify their client. Anybody remember your fiduciary duties? COLD, COALD. What does that stand for? Remember from way back in chapter 3? Cold, care, obedience,
Oh,
accounting, loyalty, and disclosure. Those are your fiduciary duties. Obedience includes confidentiality, disclosure includes notice. So anything that's told to you, you have a duty to go back and notify your clients about it. So in contract negotiations, when's an offer considered accepted? If the other side tells you, hey, my client accepted your client's offer, that's when it's been accepted. Now, this can be done verbally. However, it's suggested and always a good practice to follow up with getting it in writing. But you need to be aware for exam purposes and exam purposes only. When is an offer in contract negotiations, when is an offer considered accepted? Only when the other party has been notified of their acceptance. Now, even though I said it's a good practice to always follow up with getting it in writing, because you're going to need it in writing. Otherwise, how do you start attorney review? What are you going to say? Hey, attorney, where you got a contract, although it's not in writing? And they can tell you, well, get it in writing. Because remember, contracts for the sale of real estate in New Jersey must always be in writing. So you're going to have to follow up and getting it in writing to start the attorney review process. However, for an exam question where they ask you in contract negotiations, when is an offer considered accepted? It's simply when you've been notified that it's been accepted. Important. That's why I'm spending some time on this, repeating it over and over. All right. So earnest money deposit, what is that? It's any money that the buyer puts down when purchasing real estate. At minimum, when they're making an offer, you as the real estate agent should get a deposit from them of $1,000. They should have at least $1,000 if they want to buy a house, right? Now, the earnest money deposit should be large enough to convince the seller to accept your offer, that you're serious with your offer, and that you intend to go through with it. So basically, you're asking the seller to take their property off the market and accept yours. So that cash deposit should be sufficient enough to convince the seller. So it should be at least $1,000. You're going to need more money to put down than that, but this is the minimum that when making an offer. I shouldn't say this is the minimum, because legally, no cash deposits required, no good faith deposit is required, and an offer is still considered accepted, even if it's not accompanied by a good faith deposit. However, I would always try to get them to put down at least $1,000 to show their intentions are serious. All right. Otherwise, your client could be playing you too. They could be putting offers in with different agents on a lot of different properties, throwing offers at the wall and seeing what sticks, So it's always a good idea to get them to put down at minimum $1,000. Get them to put a little of their own cash into the transaction. So this way, if they're just screwing around, throwing offers around, and they weren't serious, the seller can make a claim to keep that deposit money. Okay. Now, if that offer is not accepted, that earnest money deposit is immediately returned to the would-be buyer. They cannot use a credit card for earnest money deposits. That's a little notation they put there. Wonder if that's on exam at all. A credit card may not be used for an earnest money deposit. It has to be a cash or a check. So once again, the amount of the deposit's a matter to be agreed upon between the parties, and generally the deposit should be sufficient enough to discourage the buyer from defaulting and to compensate the seller for taking their property off the market and covering any expenses the seller might have occurred if the buyer defaults. A purchase offer with no earnest money deposit, however, is perfectly valid, but I would never take one that way. I would always ask the buyer to put down at least $1,000. I mean, are they serious about the purchase or not? Okay, so on page 218, this is a continuation of that earnest money deposit. I want you to write at the top of the page, liquidated damage agreement, not standard in all contracts. And I want you to replace the word, I forget what word it is that they have here. It may be all contracts. You should write some. It's good to have one of those whiteout inks. And then you're just continuing highlighting the definitions here of the or the explanation of the earnest money deposits.
Got it.
All right, everybody good?
Yes.
All right, so now here's my interpretation or rewording of that, everything that you highlighted there. Earnest money deposit is sometimes referred to as the good faith deposit, and this is the money the buyer puts down when they make their offer. It shows the buyer is operating in good faith and they plan to complete the transaction. An offer is still valid even if made without a good faith deposit, which is customarily at least $1,000. The buyer is basically asking the seller to take their property off the market, so they want to make sure that that deposit is large enough to show they're serious with their intentions. And if the seller rejects the offer, the earnest money deposit would be immediately returned to that would-be buyer. If the offer is accepted, the money will be credited towards the buyer's purchase price. If the buyer breaches the contract, the seller could possibly make a claim to keep it. Both parties would have to agree to that. And if they don't, only a judge could decide who gets the money, because a broker can't release those funds unless both parties are in agreement on who to release it to. So if there was a liquidated damage agreement added to the contract, which specified that the earnest money would serve as damages, then they could take it. The brokers must deposit any money given by our clients into an escrow account, escrow or trust account. There are two names used to describe the same thing, a bank account used only for keeping our clients' money in for short periods of time. It must be deposited there within 5 business days of acceptance, not of the offer being accepted, but within the 5 business days of the agent accepting the money from their clients. Any cash deposit of $10,000 or more, we need to report it to the IRS. And a broker is required to keep those escrow records with all them bank deposits and deposit slips, etc., and escrow books, records for 6 years. So once again, the meeting of the minds is when all parties are in agreement on all the terms, all the details of the contract. And once again, the school exam focuses on price, down payment, and financing method. How are you coming up with the rest of the cash? A kickback is giving anything of value to an unlicensed person, like giving a friend money or a gift in exchange for a lead, including rebates to sellers, because sellers, we can't give them anything back. Rebates to sellers is not legal in New Jersey. Only buyers purchasing a primary residence can receive rebates legally. And therefore, it's not a kickback. And in those cases, we're not paying them directly anyway. It's going to be a direct reduction of our commission at the closing in the form of a credit or check. We're not writing out a check and handing it over to them. The closing agents are. It's not coming from us. It's getting deducted from our commissions before we're ever paid. Important to know. Closing gifts to buyers should be limited in value so that it cannot be in any way perceived as receiving a kickback. Shouldn't keep them up too high. And here are some of the essential elements that are required to be in any valid contract. Contract has to be in writing for the purchase or sale of any real estate. You have to have competent parties, an agreement to buy and sell, an adequate description of what's being sold. The consideration has to be fully stated. The grantor's agreement to convey the property, the place and time of closing, although that can fluctuate, and the signatures of the parties with initials on every page. These are not essential elements of the valid contract because not all contracts may have all of these components. But if they do, they should be added into them. Encumbrances to which a deed may be subject to, any deed restrictions, if there are any. Earnest money deposit. If they're making a deposit, they're not required to, but if they do, how much is it? When do they give it to us, etc. Where it's being held. Mortgage financing, the buyer plans to obtain. The possession by if they're getting a mortgage, some people are buying cash, it depends. Possession by the buyer, when can they get that possession of that property? Any title evidence, prorations and adjustments. Well, those are final figure adjustments that the closing agent does. They don't put that in a contract. Destruction of the premises. In the event there is a destruction of the premises, what happens during the contract? We have these things written out and spelled out in our contracts, but it's not essential for the contract to be valid to have those in it. Default, what happens in the event of default by either party? We have something about that in our contracts, but once again, it's not a required element. Neither is spelling out that the buyer has the right to do a final walkthrough on the day of close or whenever. But yet we have something pertaining to that. And any contingencies, because not all, we should be submitting contracts as contingency free as possible. Contingencies are happening in which a contract is dependent upon. And then signatures of witnesses are not required for any contract to be valid. You don't need to have witnesses, just both of the parties need to sign it. Here's some examples of common contingencies added into sales contracts. There could be an FHA and VA loan contingency. We call it a special contingency clause. Basically says that both of the parties, or if the purchase price does not, if the house does not appraise for the purchase price, that the buyer can get out of the contract without penalty. It could be subject to engineering reports. It could be an escape clause added, a liquidated damage agreement, or short sale clauses. It could be subject to family members' approval. Sometimes we have relatives that are paying for the house or giving money to help with the down payment and closing costs, for example. If a contract is contingent upon that, we need to know. Because you as a real estate agent, you need to get these people into the house and look through it and give their approval before you ever write up the contract to submit that contract as contingency free as possible. But if that's not possible, then you need to write their names in the contract that this contract is contingent upon these people walking through the house and giving their approval because they're helping with the money to finance the purchase. Now, the more contingencies like this stuff that you add to a contract, it's the more opportunities that a buyer has to get out of the contract, and the less attractive it seems to sellers. So keep that in mind. If the purchase is subject to any zoning or building permit approvals first. Look, just look at any commercial purchases. Often developers, they buy large pieces of land and they make it subject to many kinds of permitting requirements and approvals and zoning and building and all that stuff, and them being able to obtain the financing. So usually they put a contract in to buy a property, but they don't actually go through with the purchase of the property that they're planning on buying and developing until they get all their approvals in place. They make the contract contingent upon them getting all of these things. So let's do some notes there, page 219. Next to contingencies, just write subject to, because contingencies are usually added into the contract by saying that the purchase is subject to, and then they, fill in the blank. Whatever the reason, what is it subject to? What is that stipulation? And this on the side, by the way, it says escape, comma, kick out, comma, knockout clause protects the seller. And I put a little bracket around those lines. So an escape clause allows a seller to look for more favorable offer when I'll go over it on the next slide. Just do the highlights.
Good.
I'm good too.
All right, so once again, contingencies are happening in which a contract's dependent upon. So they often start with the term subject to. And if those terms are not met, they could get out of the contract without being in breach of contract. So agents should address and remove any contingencies that they may have added to contracts as soon as possible. There's often an appraisal contingency that's added. It's required to be added when FHA and VA loans are being used. They refer to that as the special contingency clause required by FHA and VA loans. You need to know what its purpose is. It says that if the property does not appraise for the purchase price, the buyer can get out of the contract without penalty. A home inspection. You're not required to get a home inspection, but for your protection, get a home inspection, right? And make sure it's done by a licensed New Jersey home inspector. Subject to mortgage loans, but you could buy cash, approval by family members helping with money to buy or for down payment. These are all contingencies. Purchase is subject to the sale of a buyer's current home. Yeah, because they may not be able to swing the payment on 2 house loans, right? for two houses. Most people can't. So if a buyer puts a contingency clause in their purchase contract that says that the purchase is subject to the sale of their current home, if the seller agrees to accept that offer, if I was their agent, I would insist on them adding an escape clause, also known as a kick out or knockout clause, that protects the seller. It says that we'll accept your offer contingent on the sale of your current home. However, if in the meantime, we're going to be allowed to continue marketing the home for sale, and if we get another offer in writing that's acceptable to the seller, we're allowed to, we'll come back to you and ask you if you're prepared to remove that contingency yet. And if you're not, then we can kill the contract with you and not be in breach of contract so that we could accept the other. That's what an escape, kick out, or knockout clause does. Did everybody understand that? What I just explained?
Yeah.
Okay. Expiration of a buyer's lease, because maybe they're leasing and they don't own, but maybe they're just leasing a home somewhere else and the landlord won't let them out. So the purchase is subject to the end of their lease. Or if they need to get a use permit for the property for zoning purposes, the purchase could be subject to that. Or a building permit. Or if it's subject to any third-party approvals, like if it's a short sale or bankruptcy sale, estate sale, and you need approval from a court. You better write that in. We already have this highlighted right on page 219, the liquidated damages agreement. Yeah.
Yes.
Yeah.
New Jersey does have a plain language requirement to be added to all sales contracts. However, it's kind of meaningless, really, because it only applies to contracts that are for properties that are valued under $50,000, and there's not a whole lot of them here in New Jersey, are there? So the contracts, this plain language requirement says that contracts for the sale of real estate have to use words that are common in the everyday English language that do not have a separate legal meaning to them. We call that legalese. So that's New Jersey's plain language requirement. It's amazing they didn't update the price on that, saying that it applies to the more expensive properties as well. And here's that slide with the rights of rescission again. Basically says that a property, what are the rescission periods? They vary depending on what kind of contract. We're all now all these up here are dealing with new construction sales, except for the last one, which deals with both resale of existing properties as well as new construction. There's a 3-day attorney review period. There's a 5-day period for new construction for the discovery of off-site conditions. There's a 7-day rescission period for large in-state subdivisions, whether there's 100 lots or more, or if there's less, but not less than 10 units. If there's common area elements involved, they get back out within 7 days of signing a contract. Or for 7 days for out-of-state properties marketed to New Jersey residents, like with timeshares, for example. They're talking about new construction here only, though. And then there's that rescission period for financing contracts of the loans. There's a 3-day right of rescission for refinancing property that you already own. Refinancing is when you get a new loan that pays off your existing one. And then we have a 0 day. There is no right of rescission for purchase money mortgages. So what is a purchase money mortgage? It's any loan used to buy real estate. That's a purchase money mortgage. So it's not a particular loan, it's a whole class of loans. So let's do those highlights and we put those notes in. Page 219 and 220.
I think the book is a little different.
Yeah, it is. That's how you see that part of it there is on page 219. And then
Yeah.
other part is on 220. What is the wording different?
Yeah, the New Jersey Planned Real Estate Development, full disclosure, Act cooperatives, subdivided property, the purchase.
Oh
Yeah,
yeah.
the next
Yeah,
sentence is a little different. The
yeah, it's a
purchase.
little bit different. Yeah. Let me snap some pictures of that. And,
Oh, there it is. Okay, the purchase is after under both laws.
yeah, they just added a couple words, but it is a little bit different. So I'll take
So
some screenshots and update that.
7 calendar. Okay, got it.
Either way, the previous slide that I had is probably easier to study from anyway. With this, just study your rights of rescission instead of the ones that are peppered all over and they're like this, where you got to read whole paragraphs to figure it out.
Yeah.
I'm just giving you those in addition to the notes.
Okay, got it.
And you wrote in purchase money mortgage here and no right of rescission.
Yep.
Then on 220, yeah. Also on 220, option agreements. We're just highlighting the title and the last sentence there. Yeah, I know it looks a little bit different, but it's all the same wording there, really. We're highlighting in New Jersey should be prepared by attorneys. So all option agreements, those option contracts, they should be prepared by attorneys to avoid the unauthorized practice of law, of course.
Okay, got it.
And then land contracts. I'm not sure if we ever skipped forward to page 220 to highlight this or not, but do so now if you didn't.
Got it.
And land contracts, not to be confused with a ground lease. Here's my definition, my explanation of this stuff right here, so that you could study it and know what it means. What is a land contract? Don't confuse it with a ground lease that we're going to go over in the next chapter, 12. Land contract is a type of seller financing, sometimes known as an installment sales contract, where the buyer makes payments in installments and they wait for the deed. It's kind of like a lease to own. It is basically a lease to own. You're leasing it, and the owner doesn't give you the deed to the property until you pay off the full amount that's owed. And until the buyer pays off that full amount, they don't get the ownership. However, they do have a financial interest in the property through those payments that they've been making, building up equity towards the ownership, which we call equitable title. So even though they don't own the real estate, they do have a financial interest towards its ownership. So if the buyer fails to continue making payments, the seller does not need to go through the hassle of foreclosure because they're not the owner of the property. But it's harder to get them out than just an average renter because they're more than a renter, less than an owner. So it's easier to get them out than through foreclosure of an owner, harder to get them out than a simple renter because they're more than a simple renter. Make sense?
Yeah.
Equitable title is that financial interest towards equity and title. Title means ownership. Equity comes from the root word equity, and equity is the difference between the market value and what's owed on the property. It's built-in value. So the value that you built up through those periodic payments towards the ownership, that's equitable title. You see how we get to that conclusion of if we forget what the term equitable title means, just look at what is equity, what is title, put them together, and then you could make reasonable deductions of what it means. Okay, in a sales contract, we need to prepare items that we need to prepare a sales contract. This is just something I threw together. You're pretty much done with this chapter. This is just the stuff you need to toss together in order, these are some tips in order to put the contract together. Well, you could go to that realtor.com/zip form, or you could go to the domain name that I bought that points there. That's njrforms.com, which is easier to remember for me anyway. And that takes you to the contract form system that is part of our, it's paid for with our realtor dues. So njrforms.com is just a domain name that I bought that points you to njrealtor.com/zipform, the contract form system that we use to prepare our digital contracts. Unless your broker has their own that they're using, but more than likely they're going to be using this one. Then you're going to go to the MLS and you're going to open the tax record for the property. Every MLS has access to at least one tax record system where you can get that information. Then you're going to print the MLS listing for that property or just have it open in another screen because there's some information you're going to need to grab from the listing to put into the contract. You're going to need to have another window open on your computer to gather all the license, the license numbers for the real estate companies as well as the individual real estate agents involved, because the law now requires that all real estate agents have their license numbers added to the contracts there next to their names. And you could do this by going to njreclicense.com, a domain name that I bought that just points you to the Real Estate Commission's database. This one does as well, njrealestatelicensesearch.com. And you could also use this resource, although this resource doesn't have like all the addresses and everything from njrealtor.com/license. Here's another search. This one though, now let me show you the difference. And in that one, it takes you here, and you could look up the reference number, which is the license number of an agent, by putting their name in here. So I'll put in my name, Kaminsky. All right, and I'll just put in my last name. Let's see, how many Kaminskys are there licensed in New Jersey? Wow, there's a bunch of them, it looks like. Okay, well, either way, I'm Victor. I'm the only Victor here. So, and I'm the broker of record of 2 agencies. Here's my real estate agent license number, and here is my office license number for the 2. Now, if my one company is putting together this, I could just click on that, but it doesn't give me all the address information and such it just gives the license numbers. But if I were to go to, let's say, NJ Rec License or NJ Real Estate License Search, which points to the long domain name that the Real Estate Commission, to the Real Estate Commission website, it takes us here. And then I could put in my name, Kaminsky, comma, V, and I'll just leave it at that. And now I got the address of the brokerage firm. I got the status of the licenses, the license numbers, everything right there. And then pre-qualification, you're going to need a copy of a minimum of the pre-qualification letter or mortgage pre-approval letter that your borrower has to get that loan. If they're buying all cash, we're going to need the proof of funds letter now, because we're going to need to submit that over with the contract as well. And those pre-approval letters will tell us how much money the buyer needs to put down. So when we're preparing the contract, we can make sure that they're putting down at least that much. And that's dependent on the type of loan they get. So we should really ask the buyer how much money they're putting down. We don't just go by the minimum amount that the lender requires. We're going to ask because sometimes the buyer will put down more money. But we know what the minimum is that they need to put down through that pre-qualification or pre-approval letter. And then don't forget that deposit check that we're going to need from that buyer for the good faith deposit. Make sure that we get certified funds or a bank manager's check. You could accept a personal check, although I don't recommend it because people sometimes bounce them. And then that opens up a whole other can of worms. We should get the lead paint addendum from the listing agency. If the property was built prior to 1978, they should have a lead paint addendum there that was first filled out by the owner. Often we could just look in the MLS and it's there for downloading as under additional documents. But if the agent never uploaded it, we're going to need to call them to have them fax it over or email it to us so that we could print it and then have the buyer read it and then sign it, as well as that seller property condition disclosure report, if available. And we should ask the buyers or the sellers what attorney they're using. Because remember, if the offer gets accepted, we got to give that duplicate original to both parties. And then we start that attorney review within 3 business days. Otherwise, that contract becomes legally binding as it is. And we're going to have to fill in some dates on the contract. Although if you don't fill them in and leave it blank, it's automatically going to say 30 days. So the mortgage commitment letter should be produced within 30 days from the date of contract there. Make sure you put a date on the contract. Make sure it doesn't doesn't land on a holiday or a weekend. And then put in the closing date, which is typically 60 days from the date of closing. Don't try to rush that because there's a lot of things that need to get done in a transaction. And typically 60 days is a comfortable amount of time for you to get most stuff done. Okay. You could close in 30 days, but that's very stressful. And everybody needs to be on the same page, doing what they're supposed to do, providing the paperwork they need to do. Everybody's got to be Johnny on the spot to get that to happen. That's stressful. 45 days is not so bad. 60 days, comfortable. Okay, usually. So the closing date you're going to set on the contract, usually about 60 days from the date of the contract. However, if that ends up being like on the second or third day of a month, push it forward a couple days so that it ends at the end of the previous month. This way, lenders will prioritize those transactions to be funded so that they get all their numbers in. Little tip to you. Never leave a blank line on a contract. If something is not needed on this universal 1 to 4 family contract, you could just write NA not applicable there or put a line through it and then have people initial next to those things. Contracts must state the amount of down payment the buyer's making, as well as any good faith deposit, customarily $1,000. However, it's not required by law. It's not mandatory. The mortgage down payment minimums, typically for conventional loans, that's 20%. Could be less. I've seen it as low as 3%. FHA, it's a minimum of a 3.5% minimum down payment. It used to be 3%. President Obama came into office. He raised it to 3.5%. Came his reelection year, just before his reelection, he lowered it back down to 3% again. This is something that you could see presidents doing. They often manipulate things in election years, upcoming election years, that are within their control to try to make or give the illusion that the economy is doing a lot better than it may perhaps be. And one of the things, leading indicators, is real estate. So that's why he manipulated that number a bit. He's the one that raised it, and then he lowered it during an election year, and then he raised it back up right after the election. How manipulative. These are things that politicians, these are games politicians play sometimes, though. The VA, the Veterans Administration, no down payments required. Now, the veteran could still make a down payment, and then they could get that money back later, or they don't have to. They could just agree to make a down payment. However, for VA loans, the veteran is not required to make any down payment because the VA guarantees 25% of the loan. So it's as if the borrower put down 25%. So the lenders usually don't require the veteran to put down any money when getting a loan to buy real estate. It's one of their benefits as a veteran or current military personnel with their benefits. Concessions. The word concession, to concede, is to give up. It's like, think about political elections for a second. When somebody loses an election, they should graciously concede the election when it's obvious that they have no chance of winning anymore. They should concede the election to the other party. Okay, that means they're giving up to the other party. They're conceding that they've lost. So it's something that one party gives up to another. So in real estate, when a seller is conceding to a buyer money that they could use for the closing cost or repairs, perhaps. Now, depending on the type of loan they're getting, there are limits on how much money that the seller can concede to a buyer. If it's an FHA or VA type loan, the maximum seller concession allowed is 6% of the loan amount, not the purchase price, but the loan amount. And if it's a conventional type loan, that maximum is 3% of the loan amount. Closing costs with loans are typically 2 to 3% of the purchase price. That's a guesstimated amount. You like that made up word I made? Is that even a real word, or is that just a made up word that I made up there? Guesstimate, guesstimated.
I'm not sure. I have to look it up.
It sounds legit, right? It sounds like something that could be real. It's a
Okay.
guesstimate. I just guesstimated it. I often do stupid crap like that. I make up words, things that sound real, but you could figure out what they mean by the way that they sound,
Okay.
I don't think it's a legit word, but hey, if it is in the dictionary now, awesome. Been using them for years.
Seriously.
And then seller's concession. So this is how to properly ask for. These are some common clauses that we add to sales contracts. I just gave a couple examples here on this slide. So if you're going to ask for a seller's concession, it's not uncommon to write it in like this. The buyer is requesting a seller's concession up to 3% towards the buyer's closing cost and prepaids. This is a concession and not a loan. So therefore, it doesn't need to be paid back. It's an amount that the seller is conceding to the buyer. Now, I put in a little crafty wording in there that may have slipped by you. It says, buyers requesting a seller's concession of up to 3% towards buyer's closing costs and prepaids. What the hell is a prepaid? I've had this slip by attorneys even, and I'm like, damn, man. I was like, I got them to sign the darn contract agreeing to this, and then you go and just ignore it. The prepaid is a detail. If you ask the seller to concede money towards the buyer's closing costs, and the closing costs don't need all that money, the buyer doesn't get to keep the rest of it. That goes back to the seller as profit, their proceeds. I'm asking that it doesn't go back to the seller as the proceeds, but it gets applied towards the buyer's prepaid interest on their loan. And if you can negotiate those things, good for you. You negotiated something extra there for your buyer. You got the seller not only to contribute towards the buyer's closing cost, but also to whatever money's not needed for the closing cost, it's going to go towards the buyer's prepaid interest on their loan. Not bad. For a short sale, you could have something as simple as a one-liner like this. This is a short sale, purchase price and commission subject to third-party approval. Boom. Straightforward, simple, to the point. Me, I have a document somewhere. It's not on this computer. I gotta locate it. I used to have a short sale addendum that I added to contracts that was like a full legal size page of all kinds of things pertain, because I used to do a lot of short sales, and I came across so many crazy issues. So I put together an entire addendum, an additional document that gets added to the contract if it's a short sale. So instead of having a one-liner, I got this whole entire document that goes over all kinds of issues that I've come across and dealt with, and what the solutions would be built into the contract if the seller is going to agree to purchase to the sale. They got to agree to all these terms in that addendum. Now, only if, usually with short sales, the seller is not going to be responsible for the obtaining the CO and the fire certificates, which may require repairs done to the house in order to obtain them. So sometimes, usually, but not always, they'll say, listen, we're not getting this. You have to get it. The buyer needs to get it. So only if they specify that, you would add something like this clause into the sales contract that says, Buyers responsible for obtaining CO and fire certificates. Okay. CO here, we're not talking about carbon monoxide. When we talk about CO here, we're talking about the certificate of occupancy and fire certificates. Now, buyer home sale contingency clause. That's a mouthful. Well, I guess that's what I'm going to call it. A buyer home sale contingency clause. So this is a if the buyer has another house they need to sell before they go through the purchase of this one, you could just write in the contract, purchase subject to the sale of the buyer's current home, and then give that address or MLS number if it's listed. And then also state what the status of that contract is. You know, I hope it's already on the market. I hope it's already under contract if you're putting in an offer on another house. Because the seller could say, wait a minute, you're asking us to accept the property subject to the sale of your current home and you haven't even put it on the market for sale yet? They may want it to be on the market for sale already. It'd be even better if it's already under contract with an anticipated closing date, and then you'd spell it out if you got all that information. But either way, you should spell out what the status of it is if that purchase is subject to the sale of that buyer's property. Now, let me see. It looks like I got a form linked to here that says form if not just typing in the contract this clause. There actually is a home buyer's addendum regarding buyer's property sale contingency. That's what they call it. So it looks like the Realtors Association finally put something together about this. Well, they put it together a while ago already, I guess. Let me see. Is there a date on this? 8/16. Oh, it doesn't say the year. All right. So they got a if the buyer's property is under contract, if the buyer's property is not under contract, and if the closing on the buyer's property is delayed. Okay, so this goes over a lot of the contingencies if this purchase is subject to the sale of the buyer's current home. Okay, you use one of these addendums regarding the buyer's sale of their current home. And then relatives approval, if it's subject to family members giving money towards the purchase of the property. You just write there in the contract, purchase subject to buyer's relatives, and then name them. Viewing the home and approving the purchase, they'll be contributing money towards the purchase. Okay. You really should do this before you ever write the contract, so you don't need to put this clause in there. Because like I said, if you submit a contract that says your objective should be to submit a contract as contingency-free as possible. The more contingencies you add, the less desirable this contract is to the seller. So if there's a multiple offer situation, the one that has more contingencies to them or more restrictive contingencies gives this buyer more opportunities to back out. It's not good. It's not better for the seller. Better for the buyer, but it's not better for the seller. So your goal should be to submit a contract as contingency-free as possible to make sure your offer is more desirable to get accepted. But sometimes there are contingencies. We got no choice. We have to add them in to protect our clients. Now, I'm saying try to get all the family members through there. And listen, anybody can help with the purchase of real estate, family members and all that. But I'm going to tell you, by far, you see this way more common with Indian families. By far, that they tend to work more together as a unit, that they'll even have distant relatives that'll be kicking in money to help you buy the house. All right. So if they need to get into the house and give their approval first, you need to get them all through there. Otherwise, you're going to be writing down names of many family members there that is possible. So that is like each family member that you name, that you write down, that's a contingency that's an out for the buyer. It doesn't seem very enticing for the seller. You're writing down 10 people's names or more. I had one situation once where there was 3 carloads of people I had to get through the house to show it to them. And I start writing down the names to prepare the contract. They're like, "Oh yeah, yeah, yeah. Well, yeah, these our relatives are helping. We're not buying with a loan. We're buying with cash, but our relatives are helping with it." And I was like, "Okay, so I'll put down a contingency clause with their names that they got to get through there. Is it possible we can get them through before we actually write the contract, so we don't got to put that in here? Get their approval first? That would probably be best." And because I started writing down their names, I was like, "Who is it?" And the guy's like giving me names and names and names, and it keeps going one after the other. And I'm like, this is too much. I was like, we need to get these people through the house because we can't be writing down, 10, 15, 20 names of family members who are helping you with money towards the purchase price. I was like, this is ridiculous. Um, so we ended up just getting them through the house. But I got 3 carloads of people to go through in one day to go through. I showed them the house. They all gave their approval, and then we went through with the purchase without writing any names on the contract, which makes it a lot better, a lot cleaner. And that concludes chapter 11. So let's do the key terms to review. And let's do our key terms to review here. So let's see, we got contract that's been fulfilled or one that has been signed, depending on the contract.
Executed contract.
12 is A, an executed contract. Buyer's deposit with a purchase contract. What do we call that? Buyer's deposit.
And
Earnest money.
Earnest money deposit. 9 is B. Contract with a promise by each party. What do we call it when both parties are obligated to do something?
implied contract.
Not implied.
Bilateral contract.
Bilateral?
Bilateral. Both parties, bi meaning two, so both parties are required to do something. So 2 is C. A contract set down in so many words.
Express contract.
You have to express yourself, yourself in those words, right? So that's an express contract. 14 is D. Transfer of interest in a contract to a third party.
Implied contract? No.
No.
Is it assignment?
Assignment. 1 is E. Correct. Those legally qualified to enter into contracts.
Competent party.
They are a competent party is correct. 4 is F. Protection for sellers when the buyer has another house to sell.
Escape clause.
Yeah, escape clause, also known as a kick-out or knockout clause. 11 is G. Something of value given in exchange.
Consideration.
That's the consideration that we give or receive from each other. 5 is H. A violation of a contract.
Breach of contract.
You are now in breach of contract. 3 is I, correct. Interest acquired by a buyer with a land contract.
Implied. I keep saying that.
You keep saying that. No.
Um,
What do we call the interest?
Equitable title.
Equitable title. Remember, equity is built-in value. If you've been making periodic payments, you're building up some value towards the ownership. Title means ownership, so equitable title. So 10 is J. Contract that has not yet been performed.
executory.
Executory,
Executory.
correct. 13 is K. You're probably never going to see this word again after this class. So 13 is K, executory contract. I never heard it used in the business. This is probably one of those terms that lawyers learn in law school, but so when they talk amongst their own circles, but we never hear this. We never use this term, executory. So 13 is K. An offer returned to the offeror with changes by the offeree.
Counteroffer.
A counteroffer, correct. 8 is L. Contract not put into words, but shown by one's actions, Natasha.
Implied.
There we go. We got an implied contract. So 15 is M. All right. Contract that has not yet been performed. Oh, wait. We already did that. And then we contract put into words by actions. 15. Okay. So that was 15 is M, right? We just did that.
Yeah.
Certain happening on which a contract is dependent upon.
Contingency.
It is a contingency. 6 is N. Agreement between two parties to perform some legal act.
Contract.
It's simply a contract. 7 is O. Agreement under which the buyer pays in installments and then they wait for the deed.
Land contract.
That's a land contract. 16 is P, which is a type of seller financing. It's not your typical seller financing. Typical seller financing works just like if you got a loan from the bank. The seller gives you the deed, in exchange you gave him the money. All right? Or the lender does. In a land contract, the seller doesn't give you the deed because you didn't pay them off in full yet. You're making payments in installments. This is why they also refer to it as a installment sales contract, because you're making payments in installments and you're waiting for the deed. All right, so 16 was P. All right, let's do key terms to review. 2. A return to the status quo. That means returning to the way that you began.
Recession.
Rescission. No, yeah. When you rescind the contract, you're canceling the contract out. You're returning to the way that you began. So 6 is A, correct. Another name for an option contract. What kind of contracts have options in them?
Unilateral.
Those unilateral contracts. One party has an option to act. One party's required to do something, the other has an option to. That's a unilateral contract. So 12 is B. A law requiring certain contracts be in writing. To prevent.
Statute of limitations.
No.
Statute of fraud.
Statute of frauds. So it's a law requiring certain contracts be in writing to prevent fraud. Would be the statute of frauds. 8 is C. A contract that is binding, but one of the parties can disaffirm it. Only one of the parties can disaffirm it. Avoidable contract. 15 is D, correct. Like a contract with a minor. Some agreed on to serve as damages in case of future default.
Liquidated damages.
Liquidated damages. 1 is E. The process of reaching a meeting of the minds. The process of reaching a meeting of the minds.
Offer and acceptance.
Offer and acceptance. 3 is F. Substitution of a new contract for an existing one. That sounds weird the way they word it. That doesn't sound right. It sounds better if you say substituting an old contract with a new one. The way that they worded it, I hate the way the book words things so backwards sometimes. Substitution of a new contract for an existing one. No, substitution of an old contract with a new one.
Novation?
Novation, 2 is G. A contract that meets all of the legal requirements and therefore fully enforceable.
Valid contract.
It is a valid contract. 13 is H. A time within which one is allowed to assert their legal rights.
Time is of the essence.
Mhm.
No.
You had it before, actually. A time limit in which one is allowed to assert their legal
Oh.
rights.
Statute of limitations.
That's your statute of limitations. 9 is I. You know, it's like cops can't press charges against you for certain crimes if so much time has gone by, for example. Contracts are only enforceable. You could only sue somebody for so many years for certain things. That's your statute of limitations. Cases of fraud and contract issues, that's 6 years. And for recovery of real property in New Jersey is 10 years. So those are the statute of limitations. So 9 was I. A court action usually asking that a seller be forced to sell is agreed.
Specific performance.
A specific performance or a suit for specific performance. Correct. 7 is J. A convention that written contracts override spoken promises. What do we call that convention that written contracts, they override the spoken words, spoken promises?
Is it parole evidence rule?
The parole evidence rule, because you got evidence. The courts will favor the one that's got it in writing over the one that's got a verbal contract. So it's the parole evidence rule. Correct. And 5 is K on that. A contract that does not meet all the legal requirements.
Void contract?
A void contract. So it's kind of a self-contradictory term, right? 14 is L, void. Seemingly valid contract, but neither party can sue to force performance.
Unenforceable contract.
Therefore, it is unenforceable. That would be correct. And that would be 11 is M. 11 is M. A contract binding one party, the other party's free to act or not.
Option.
That's an option. 4 is N. And a contract clause requiring punctual performance.
Time
is
of-
of the essence.
Time is of the essence. It's very important. Correct. And that concludes the very long chapter 11, which had a lot of stuff in it. We managed to get through it fairly quickly, though. It has a lot of stuff in there. There are a lot of terms, if you noticed, in that chapter, and you probably will get a lot of questions on exams based on contracts.